panel as well. Tonight I'm not going to debate use of force because I think the evidence indicates that we have a problem in this city. I want to cite two documents that I think are pretty much confirm my premise. One is NAACP Title VI complaint filed June 19, 2004 that has a compilation of all the data here for the past 10 years on police shootings. The second is a U.S. Department of Justice report that was based on our report that confirmed also in this city you have a serious use of force problem in the African American and Black community. So I don't have to debate that, it's been already pretty much determined. I want to cite also a document that was created in 2000 by the Washington Post that examines police shootings all over the country, and it shows you the ratio in each city. It also makes recommendations. There's a letter that was written in 2003 by the 403rd Judicial Court, grand jury report, that said very clearly in this city, in this county, you have a serious problem here with use of force against Black and brown people. Continuing as well, there's a list here that covers about 14 years in Austin, Texas, of previous shootings. Primarily there are Black people and brown people, a few white people. But the point of the report is that clearly going back almost 15 years, you've had a rash of shootings here where primarily Black people have been shot. In fact, at a greater period of time between 1995 and 2002. The good news is in 2002, we created the Police Model's Office. And since that time, we've had more data, and our numbers show that we've had a decrease in violence overall. But let's go forward. The NAACP has always believed in the importance of having a civilian voice in this process. And I think the numbers will show that since we had your office here, we can at least put up a defense to fight these kinds of issues. I want to share a couple of things about this whole process. I respect the fact that police officers in this city and in this country have a right to perform their duties. But I want to share something said about the Supreme Court, and it's very important. The court says that basically that deadly force is only permissible when the suspect poses an immediate threat of serious physical harm to the officer or another person in a case called Garner versus Tennessee. It says the only exception to the rule is when the suspect poses an immediate threat of harm to anybody. If the suspect is not inflicting any damage on anybody, then minimum, not maximum force, should be the policy and the procedure. And another very important case called Graham versus Connor, the Supreme Court says that in every situation involving use of force, it should be the least amount of force required in order to overcome stated or obvious resistance. So even the Supreme Court, it has spoke very authoritatively about this whole issue, but to me that's not being heeded. But let me go further, because I think this is very important. When it comes to use of force around the country, it can't be subjective, it must be objective. These cases prove that. You have a very difficult job, very difficult job. And in these kind of cases, it's not to focus on criminal intent for us, but more importantly, whether or not procedures and policies are being practiced. We know that if you don't practice policies and procedures, you're going to have negative results. And for some reason in this city, we keep having this problem. And I must admit, less so recently, because if you want to deal with facts in history, clearly over the past 2 years, there have been revised use of force policies, and there's been less force against Black people compared to the previous 5 years. But it's not good enough, because when you don't practice procedures, as all these reports indicate, if you don't practice proper guidelines, you're going to have negative results. The issue is, why do these things only happen involving Black and brown people? And that's why right now the city is on the Title VI complaint, and the DOJ is still here overlooking this investigation. We have a major problem. And I want to close by saying a couple of things that I think will help us address this issue. In the APD's own general orders and guidelines, it says very clearly, a police officer's duty is to protect the life and property of residents. It is a policy of this department that officers shall only use the minimum level of force that is reasonably necessary to bring an incident under control while protecting the lives of the officer or another. It says the amount of force used will be the amount of force which is essential for that officer to attain his or her objective. Here's my question to you tonight. On the tragic night of May 11, 2009, his officer Quintana used essential force based on the stated threat. I think when you look at all the evidence in this case, from beginning to end, including his proper procedures, for example, announcing very clearly, I'm a police officer and I'm on the scene, and giving effective instructions to surrender. In these cases, it is important that the suspect, no matter how bad I think he might be, is given the proper time to embrace the instructions and surrender. I maintain in this case that young Nate was never given an opportunity. He was never given a chance to comply and fight surrender. And as a result, this incident, to me, violates our oath, our breach, and also the fact that in this city, this is a serious injustice in our population. And